The Nigerian National Assembly has reassured Nigerians that there are no plans to suppress press freedom as the lower house proposes amendments to two media bills, the Nigerian Press Council Act and the National Broadcasting Commission Act. In a statement issued by the umbrella body of all editors in Nigeria on Tuesday, the body said that the oxygen of democracy of the media will be strangulated if the bills are passed in their present forms. The statement read, at a time, there is a popular ongoing global conversation about the need for a new deal for journalism, for immediate and sustained action from and collaboration between governments and other influential actors to improve the policy, funding, and enabling environment for independent professional journalism. We see the proposed legislations, the body argued, as unhelpful. While we are not opposed to an act that will promote media stakeholders-driven regulatory counsel, the many draconian provisions in the Honorable Odebunmi Olusegun's sponsored bills are actually aimed at criminalizing media practice in Nigeria. While the intention of the sponsor of the bills is suspicious, the bills negate all known features of media regulatory bodies in the world, the body argued. Joining us now to discuss this and other issues is Senator Ajibola Basiru, spokesperson of the Nigerian Senate. He is a senator representing Osun Central Senatorial District. He is also former Attorney General and Commissioner for Justice for Osun State. Senator Dr. Basiru, good to have you on This Day Live. Thank you very much for joining us.
Yeah, Dr. Abati, it's good to be here. Thank you very much for having me here today.
Yes, thank you very much indeed. There was this capacity building workshop for 2 days that was organized by the Institute for Legislative and Democratic Studies, led by Professor Abubakar Suleiman. And you were there. And at that particular event, you made a statement that the proposed amendment of the Nigerian Press Council Act and the proposed amendment of the Nigerian Broadcasting Act and Code, Section 2 thereof, do not amount, in your view, into an attempt to gag the media. But the Nigerian Press Organization doesn't think so. The Nigerian Guild of Editors has a different opinion. Publishers Association of Nigeria, the NPAN, and also the Broadcasting Organization of Nigeria insist that attempts by the National Assembly, either with regard to these two bills or previous bills relating to the social media, are very clear attempts by the administration, and particularly the ruling party, to gag the media, to censor the media under the guise of regulation. Incidentally, apart from being spokesman, you are also a lawyer with a PhD in law. So, should we believe what you said?
I believe that, yes, the organizations that you have mentioned, no doubt they are stakeholders in our Nigerian media industry. But with respect, elected Nigerian legislators are also stakeholders in ensuring they live up to the expectation of the constitutional mandate in Section 4 of the Constitution that we must make law for the good government and order, of the country. And I must first say that there is nothing like National Assembly legislation or National Assembly making a bill. It's good to set the tone so that the debate and the issues can be brought in proper perspective. There are two ways by which legislations are initiated for processing at the National Assembly. It could be by way of executive bill, in which case it will be initiated by a letter from the president, from the executive, to say that the executive wants this particular legislation to be put into process of legislative action so that it can eventually ripen into law. The second mode is private member bill, by which individual legislators have the right to initiate private member bill to be able to ventilate necessary legal reform they seek to do. So the current amendments being proposed to the NBC Act and the Nigeria Press Council Act are actually not from the executive. They are not executive bill. They are private member bill by chairman House Committee on Information. So we must first derobe ourselves of the sentiment as if there's a grand plan already conceived by National Assembly as a body to make a particular legislation. So now, if it's a private member bill, the process of making legislation under Nigerian law and by our procedure in the National Assembly, one, there will be first reading, there will be second reading, whereby the philosophies and principles of the bill will be discussed. And when majority of the members agree that the philosophy, policy, undertone, and the direction of the bill is in order, it will be sent to the committee level. At the committee level, the committee will look at the clause by clause. They will also conduct public hearing, have engagement with stakeholders. Then they will now make recommendation whether they will accept the bill as proposed or make certain amendments into those bills. It is after the work of the committee that the bill will be returned to the Senate in what is called the third reading. At the third reading, there will be clause by clause reading for each and every member of the National Assembly at the relevant chamber where the bill has been initiated to go through those bills and then agree whether those clauses should be there, whether there should be amendments, or so on and so forth. Even up to the question of even long title, short title, and everything will be subjected, to work by the committee of the whole. Then if the bill is passed at a chamber, let's say, for instance, the MPC and the NBC Amendment Act that is in question, they will be sent to the other legislative arm, now the Senate, because this bill has been initiated at the House of Representatives. Then there will be concurrence, which means that the Senate will also look at it clause by clause. So in essence, what I'm saying is that I will want to appeal to the various people that have expressed concern that there is ample opportunity for them to make inputs into the bill and to highlight the areas that they think will not meant well, but to say that there will not be a regulatory framework for legislation is even antithetical to the practice in all over the world. And I say, and at the risk of sounding immodest, that I talk from position of knowledge that there are regulatory body, and there has always been regulatory concern about regulation of media, particularly in the interest of national interest, in the question of preventing the public from obscenity, pornography, and insurrection, insurgency, and generally for protection of morality of the society. And in fact, I will, for instance, make an allusion to a situation in the United States of America during the Super Bowl 38, when one of the broadcasting media inadvertently or mistakenly shown the nipple of Janet Jackson. That led to serious regulatory and legal change by which the fine was raised from $32,500 to $325,000 minimum dollars, and with a maximum fine of $5 million. That is, nobody will contest that the United States of America is an advanced democratic society. So to say that there is absolute freedom of the press, absolute freedom of dissemination of information, not only is in contrary with the practice of democracy all over the world, is also not in line with Section 45 of our Constitution that makes certain necessary constitutional derogation in the interest of public safety, public security, public morality, and so on and so forth, as to the right guaranteed under the 1999 Constitution as amended. And of course, I'm abreast of the some of the concerns that have been raised by these organizations, and some of them, I may speak to them and say that these concerns, either they are not well-funded, and some of them that are well-funded, there are matters by which they should, as a stakeholder, engage the relevant committee at the House of Representatives to raise their issues with a view to ensuring that necessary amendments that would be able to address their concern are effected. But to say that there cannot be law to regulate media will be antithetical to the Constitution. In any event, the Nigerian Press Council and the NBC Act that is being sought to be amended, the extant legislation. For instance, the Nigerian Press Council is in Cap 928 of the Laws of the Federation of Nigeria, 2004. It's a 1992 legislation. So I believe that some of these concerns, if you give me an opportunity, I will talk about their concerns and how this, has been addressed by the general, law, and also how they may be addressed by they interfacing with the relevant committee of the National Assembly so that those concerns can be done. But it is not the case that the National Assembly has an agenda to stifle the press. It's not our agenda to muzzle the right of Nigerians to right to freedom of expression. You cannot have a democratic, governance when, such rights are not respected. But at the same time, just like the aphorism in human rights, theory, the freedom of your fist stop where my nose, begins. You cannot, on the basis of right to freedom of expression, destroy and injure reputation and injure proper rights of other people or cause serious disharmony and dislocation in the system by disseminating fake information leading to incitement and destruction of life and property.
Well, Senator Basiru, I have no doubts that these are issues you're well familiar with, having also served as chairman of the Senate Committee on Media and Public Affairs. But the issue is that, look, in terms of the spirit and in terms of the attitude of the two major arms of government, the executive and also the legislature, that there seems to be an attempt to censor press freedom and derogate from Section 22 and Section 39 of the 1999 Constitution. And also, in the context of the controversy over the suspension of Twitter in Nigeria, and SERAP and other bodies going all the way to the ECOWAS Community Court. This is a concern of the people, and you are there in the Senate, you are spokesperson, you are involved in media and public affairs. Are we justified to think that, look, there is a direct attempt to clamp down on the freedom of expression, particularly as the Nigerian Guild of Editors pointed out that the Nigerian Press Council Act, the Press Council Act is a matter before the Supreme Court. But somebody in the Senator Guild, was it in the House of Reps, that no, the judiciary looking into a matter does not stop the legislature from doing its work. Is that the case? Is it true?
Yes, I will address first the concerns that have been raised by the Guild of Editors and some other stakeholders as to the proposed amendment to the Nigerian Press Council. I will also, if time permits, talk about what I consider to be a rather unpatriotic and uncharitable attitude of SERAP in approaching the African court with lies and falsehood about the state of Nigerian legislation. I will address that, but to take on the respectable organizations like Nigerian Guild of Editors, and I say this with all sense of responsibility. Some of the concerns they have raised are this, and I will address them. One, they raised the issue of penalties, that the penalties that have been proposed for a breach of the provisions of the code or the law is too high. If the argument is about the penalty being punitive, let them come forward and suggest alternative penalties that would not be as punitive as the case. In any event, the essence of in criminal jurisprudence, the essence of sanction is to ensure deterrence. So if the penalties are also too light and too flimsy, then there will be no basis to really serve as deterrent. But in this one, let them approach the relevant committee to say, okay, instead of 10 million naira fine, okay, we are proposing 2.5 or 2. So you cannot say because the sentence is high for somebody who would have committed an offense, then the law, is obnoxious and seeking to stifle fresh freedom. The whole purpose of the offense itself is targeting at the veracity and the truth and, of course, the integrity of the media itself. I will say, and I know, you are a citizen journalist, yourself, you will not subscribe to a situation whereby people use press freedom to destroy the fabrics of society, destroy social life and morality of our society by peddling fake news, by publicizing unsubstantiated allegation. The whole essence is to ensure there's integrity in the media, and I think all media practitioners should embrace this. But if there are issues about the quantum of penalty, there are matters within democratic process, they could be subjected to debate, and a midway can be found on that basis. Then the second contention has to do with the fact that the fine will be being proposed is to be imposed administratively without the interface of the judiciary. I will say that, one, even if there is an administrative fine being proposed under a legislation, There is the writ of certiorari, which is a general writ, one of the prerogative writ under our law, by which anybody who feels that this administrative penalty had not been imposed in a sense that has been free and fair and has been in breach of rule of natural justice can approach any of the writ, either writ of prohibition or writ of certiorari, to quash such fine or imposition on such a person. Then secondly too, even looking at the law itself, there are provisions for criminal prosecution under the law. So it's not generally the case that it is about administrative fine and that the role of judiciary has been relegated. In any event, by section 4 subsection 8 of the Nigerian Constitution, the National Assembly cannot make a law to exclude court jurisdiction, particularly in the context of criminal action. And by section 4 subsection 12, section 36 subsection 12, all penalties for offences must be clearly stated in the enabling law. Then there is this concern about the membership of the Press Council. And the issue has been raised that there is representation by Ministry of Information. With respect, I beg to be different from the contention in this regard. When you look at the provision being sought to be amended, the bulk of the people that will be in the Press Council are media practitioners and media people in that regard. So a sole representation from the Ministry of Information, which is the official arm of the Nigerian government. And we must not forget to say that we're in a democratic government. The president, who is the executive by section 5 of the Constitution, is elected and is to act either by himself or through ministers and other government officials. So the imprimatur of the executive cannot totally be taken away in the context of regulation, because the Nigerian Press Council is an arbitrage between self-regulation and regulatory function of the government. Then the other issue that has also been raised as to the question of whether the sole determinant of whether truth has been published or not is the government authority. I beg to differ, because the composition of the Press Council in the proposed legislation is wide enough to allow men of integrity from the media to be part and parcel of those council and to raise necessary question in that. But the truth is this: we must say that fake news, misleading news, injurious publications, in fact, even under the general law, even before we talk of media regulation, there's criminal defamation. There's a problem. There are civil action in that regard. So we cannot in anywhere, any society cannot do without having some form of regulation, both in terms of content, in terms of even issue of competition in the field, and in terms of even the media by which these are done. And in terms of question of having registration for recognized media houses, I don't see any way that will contradict the right to freedom of expression under 39. You can say what you want to say in your private capacity, but if you want to have a medium by which you want to disseminate information, then there must be some modicum of professionalism, integrity, to be able to ensure that the entire society is not put in jeopardy. All over the world, the jurisprudence of human rights has always been how to find a balance between the right and freedom of the people and, of course, what is recognized as public interest. Of course, what is recognized as public interest would differ based on the temperament and democratic credential of every society. Our aspiration is to be a genuine and true democratic society, and the National Assembly will not do anything absolutely that will be unconstitutional in terms of exercising its legislative power in Section 4 of the Constitution. In any event, by Section 1, Subsection 3 of the 1999 Constitution, there is the superiority clause by which if any law is made against the Nigerian Constitution, anybody can approach the court to declare such law to be illegal. And that is why when I look at the petition filed by SERAP, I find it with all respect, with all sense of responsibility, to be irresponsible for them to make false allegations that there are no remedies under Nigerian law by which the question of legislation that is still being proposed cannot be made. One of the remedies you have is to interface with the legislative body to ensure that those laws are not passed as they have been proposed, and by suggesting reason for the democratic representative on why they should not pass the law as it's been proposed. The other alternative that you have is also to, even if that law is passed in that regard, to approach the court, citing relevant provision of the Constitution and possibly the African Charter on Human and People's Rights, which the Supreme Court has said is also justiciable under Nigerian law by virtue of Section 12 of our Constitution, and said those clauses are against it. But to go and be slandering our country, defaming our national sovereignty, defaming institutions like the National Assembly on the basis that you are a non-governmental organization is not patriotic and is not in line with even democratic tenet. Truth cannot be sacrificed on the basis of projecting human rights. Senator
Basiru, are you saying invariably that Nigeria is not covered by the ECOWAS Community Court? Is that what you are saying? But I'm aware that SERAP has also approached the Federal High Court in Abuja on the same issue.
Dr. Abati, I'm a student of international law, and I say it with all modesty. When you want to approach international, international venue for such adjudication, they ask you, have you, there's what is called the concept of exhaustion of local remedy. So they will ask you, do you have local remedy? It is only when you don't have local remedy that the ECOWAS court or African court or any other international means of resolving dispute will entertain. So what I'm saying is that the SERAP lied in their communication to ECOWAS to say that there is no local remedy here to be exhausted. It is irresponsible, and I say it with all sense of responsibility.
But there
are local remedy, you can interface with the National Assembly, you can challenge us in court. So I'm not saying they are not free to approach, but they must approach with truth, with integrity of what they want to take to the international forum.
But Senator, I just said this same SERAP approached a Federal High Court in Abuja, and if, there is a sense that the Nigerian system is not going to pay enough attention to the issues that they have raised, are they not under liberty to invoke Nigeria's obligations under international law? But that's another issue. Maybe we should leave this issue.
Exhaustion of local remedy means that they should pursue their case with respect, Dr. Abati. Exhaustion of local remedy. The Federal High Court is not the final court in the rest of the matter in Nigeria. You also have right to appeal to the Court of Appeal, and you have ultimate right to the Supreme Court. It's after you have been able to exhaust those remedy. That's why they call it exhaustion of local remedy, not exploring local remedy. Exhaustion means that you must have subjected yourself to the adjudicatory process in the country. But I wouldn't say they should not approach, but to approach an international forum with a falsehood, it's very abhorrent, and it's not even in line with what an organization set up to pursue integrity in public governance as our SERAP is reputed to be done.
Well, I see you've not commented on Twitter specifically, but in any case, maybe I will leave
on
that.
Twitter, I will say with all sense of responsibility that the question of Twitter, for me, is neither here nor there. And I say this because there are acts that are called acts of sovereignty. Part of the act of sovereignty in international law is to determine to what extent you want such kind of activity to occur in your country. And I specifically refrain from commenting because the National Assembly, particularly the Senate, which I represent, has not had the opportunity to table the matter. And I wouldn't want my personal opinion to be seen as representing the opinion of the Nigerian Senate, because there is the tendency to say that because I'm spokesperson of the Senate, anything I say represent the opinion of the Nigerian Senate. That's why anytime I grant interview, I try to make that bifurcation, that I speak as a senator, representative also Central, is different from speaking as representative of the Nigerian Senate. As of today, the Nigerian Senate has not considered the issue of the ban on Twitter. And in any event, the way we can approach it is either by way of resolution. And I know that as a matter of law, the resolution of the National Assembly is advisory, highly advisory, but has no legal bindingness and a judicial authority to that effect. By making law, today, I'm not aware of any law that has been made in that regard for us to comment whether there's been a breach or otherwise in that regard. So I think questions about Twitter is better placed at the doorstep of the executive, are represented by the Office of the Minister of Information and the Office of the Attorney General of the Federation.
Well, Senator Basiru, in the week that just ended, specifically on Tuesday, the lobby of the National Assembly became more or less an extension of the Atlantic Ocean, with a flood taking over the space between the two chambers. And yet Nigerians have been told that 37 billion naira had been earmarked for the renovation. The Senate president had said, well, they had not collected any money, and that in any case, this was the responsibility of the Federal Capital Development Agency, the FCDA. And the FCDA is saying, well, it's not their fault, it's the fault of the Executive Council of the Federation, which has not yet given approval for the cash backing of necessary funds for renovation. But there is another 9 billion naira, however, it's been pointed out, that was included in the 2021 budget for general services and maintenance of the National Assembly edifice. Has that also not been cash backed? What is the truth? Because Nigerians were shocked that the National Assembly, the alloy chambers, the lobby of the alloy chambers became flooded.
I will say that, Dr. Abati, I was shocked by two things. I was shocked at the state of dilapidation of the National Assembly because I was at the chamber on that day. I was also shocked at the level of misinformation by supposedly reputed media organization as to what actually, happened. I was shocked that a media organization that I will not mention, went to town to say that 37 billion had been released to the Senate or the National Assembly, and that loan revision was done. With respect, and I stand to be corrected by available document. Initially, there was a proposal for 37 billion because the concern of the National Assembly leadership was as to the fact that for more than 2 decades, there has not been any renovation or maintenance work carried on that edifice. Then a proposal was made by the FCDA for rehabilitation and maintenance of the place for 37 billion, which was approved by the under the 2020 appropriation. And I said that was approved for the FCDA and not for National Assembly or the leadership of National Assembly. The National Assembly complex, as well as the presidential villa, is a part of the national monument under the purview of the FCDA and not the National Assembly or the executive. So any budget that will be appropriated is not for National Assembly, is not to be released to National Assembly, is not to be expended by National Assembly. But the 37 billion was never released. It has to be even reviewed down to the 9 billion that you now mentioned. So there was no a case, there's no case of separate 37 billion and the 9 billion. It was the 37 billion initial appropriation that was reduced to 9 billion so that the remaining money could be made available to combat COVID-19 pandemic under the revised appropriation for 2020. So it's not the case, and either the 21 billion that has been amended to 9 billion, and the 9 billion, according to FCDA, no amount has been released, and they are just in the process of ensuring that necessary procurement processes are complied with. So it is not as been projected by some section of the media that the National Assembly leadership has been found wanting in the job of maintaining what is not even their responsibility. The responsibility of us as National Assembly members is to make law, to oversight execution of a government project that fund have been appropriated, and of course to scrutinize appointment. It's not part of our responsibility to oversee the maintenance and rehabilitation. And we are actually alerted the Nigerian public to the state of dilapidation of the National Assembly, but then it was being projected falsely as if it was an attempt to divert funds for what purpose it is. It's an embarrassment to us too as national legislators that the place where we're supposed to dispense our services is in such a state of dilapidation to attract unwarranted media attention. But we also want to plead with a media practitioner that when such occur, they should at least fast check and check with us so that we're able to put the proper information in the public domain.
Well, Senator Basiru, you talked about the dilapidation of the National Assembly complex. What is the extent of this dilapidation? I hope a day will not come when Nigerian representatives and senators will have to start taking swimming lessons to be able to get to their workplace. Doctor,
I trained as a lawyer. I'm not an engineer. I'm not a structural engineer. I'm not a civil engineer. So I wouldn't know. And I've not studied any document that's will let me have knowledge of the extent of dilapidation. But with their affairs have been expressed by the management of the National Assembly as to the extent of dilapidation, but I will not be able to give an informed, truthful comment on the extent and state of dilapidation.
Well, Senator Basiru, the Senate, I think the Senate president was quoted as saying that the names of certain ministries, agencies, and departments of government may be soon published by the Senate for one simple reason, that those MDAs have refused, continue to refuse, to cooperate with the Office of the Auditor General with regard to audit and the campaign against corruption. Some of those agencies were named, but how really bad is the situation? And would the Senate carry out its threat?
It's quite unfortunate, just as the president of the Senate, Dr. Ahmed Lawal, pointed out, that some agencies clearly are violating the provision of the Constitution that allow the National Assembly to oversight the expenditure of money that have been appropriated to guide against inefficiency and expose corruption. And of course, the matter had been raised with the executive. And one of the areas that I think the National Assembly may look at is to examine our law on privileges and see whether we will not need more effectual sanction on those agencies and individuals holding those agencies. One on the top of my head, I think we should be able to be looking at possibly criminal sanction against the holder of the offices where there has been refusal to open the books for the purpose of allowing the National Assembly to carry out their responsibility with a view to guide against inefficiency and exposing corruption.
Okay, well, very quickly, some other topical issues within the polity. Open grazing. Maybe on this, you would like to give your personal opinion because in this regard, the issue was brought again to the fore by 17 governors of the southern states of Nigeria, including the governor of Osun State. And then the other issue is restructuring, which the president of Nigeria says is the responsibility of the National Assembly and not the responsibility of persons who have not been in partisan politics and who do not even know how to win elections. And many Nigerians are concerned. Is the National Assembly really committed to the process of restructuring constitutional amendment, or is just going through all the motions just to give an impression of seriousness?
I will address the issues one by one. On the issue of open grazing, and just as I have said, this is my personal opinion, and I am not speaking on behalf of the Nigerian Senate. I've studied the available Nigerian law, and I will say that I am in a very advantageous position to give an informed opinion. I did my PhD in property law, so I'm well familiar with the Nigerian law on property. I will say that in the northern part of the country, there is the Northern Nigerian Grazing Law number 4 of 1965, which prohibits open grazing and only allowing grazing in the grazing areas created under the law with specific procedure and what they describe as trade routes. And I look at those laws, even what constitutes a trade route was not defined under that law. So it's left to be guessed what is meant by trade route. But grazing reserves were defined and they were area appropriated according to certain procedure for those purposes. And there were express penal provisions against grazing outside the grazing areas in those laws. I've also looked at some of the northern states that emanated from the former northern region of Nigeria. Some of them like Bauchi, Gombe, Katsina, Kwara, they have domesticated the grazing law as part of their law. But in the last compilation of the laws of Jigawa State, I think that law is omitted from their compilation. I wouldn't know what is reason, but by section 318 of the 1999 Constitution as amended, where a law operates as a state law, then the state can, subject to necessary modification, adopt same as part of their existing law. In the entire southern Nigeria, there is no law on grazing area, and throughout Nigeria, and I stand to be corrected by anybody who have better information, there is no law gazetted that is creating anything like grazing, route at all. And that was why I said possibly the executive had been possibly misadvised as to the existence of any law on grazing route. And as to the declaration of the southern governors, 17 southern governors on the prohibition of open grazing, yes, the governor of my state, Ajibola, was part and parcel of that communique. But beyond that, as a Nigerian, I believe that the current method of rearing animal needs to be modernized. We cannot continue to use the nomadic system, which has become archaic, particularly when it is leading to tension, leading to destruction of property of innocent people and destruction, of farm. And I say with all sense of responsibility that it is within the right of the state governors, going by provision of section 1 of the Land Use Act and all other provisions, to make necessary laws and regulations as to grazing and other form of use and management of land. So what I will advise is that the 17 governors in the southern states should go ahead and get the attorney generals and state assembly to make necessary law to give effect to the declaration that I've made. But beyond that, they also need to embrace and encourage good modern animal husbandry methods in their referral state, so that there can be proper means of carrying out animal rearing, which will not impinge on the rights and liberty and property of other people. I'm not oblivious of very contentious and rather unfortunate comment by some people seeking to equate the position of the southern governors on the issue of open grazing with banning people from carrying out business in the north or anywhere. It's unfortunate that as statement we could degenerate into making statements such as to generate tension and ethnic animosity. The truth is that nobody has banned any business. Nobody has banned anybody from rearing animals. What is being said is that animals should be reared within the ambit of the law in a way that will not constitute threats, actual or real, to other people's lives and their property. And I think the right to freedom of movement under the constitution that has been referred to will not allow anybody to move his own animals to other people's property for the purpose of destruction or purpose of attacking such property. As I said, we must have it at the back of our mind when we talk of right and freedom, fundamental right and freedom, that the right to, with your fist anyhow, stop at the next man's nose. You cannot exercise your freedom in a way that impugn on the right and freedom and liberty, and particularly the right to property of others. On the issue of restructuring, I will say that yes, by the existing ground norm, which is the 1999 Constitution as amended, Section 9 played very important role on the National Assembly in terms of amending the Constitution by the requisite 4/5 majority, which would then be passed on to the State Assembly by 2/3 of them to so agree. But I will say with all sense of responsibility, as a member of the All Progressive Congress, as a candidate of All Progressive Congress, which got me voted into the Senate, that our party made covenant with the Nigerian people in 2015 and also in 2019 about restructuring and devolution of power. In furtherance of our promise to the Nigerian people, a committee was set up, headed by Governor of Kaduna State, Malam Nasir El-Rufai, and the committee also has a senator. I know Senator Adetumbi, a current senator from Ekiti, was the secretary of that committee. And I think Ogbeni Rauf Aregbesola, former governor and now Minister of Interior, was a member of that committee. The committee made far-reaching recommendations on devolution of power and restructuring. I believe that the executive of Nigeria today, as represented by Mr. President Muhammadu Buhari by Section 5 of our Constitution, also have a role to play, particularly if the exercise carried out by my party, APC, will not be an exercise in futility. So it could not be out of the way for the president to introduce an executive bill with a view to seeking the National Assembly mandate to pass appropriate legislation in terms of constitutional amendment to put in place what has been the report of a committee of my political party. But be that as it may, I am a member of the National Senate Constitutional Review Committee. I represent my state of Osun, in that committee. And I know that part of what is being considered is the report of the El-Rufai Committee, as well as the 2014 recommendations of the conference. In fact, I was a member of a subcommittee headed by the former governor of Borno State, Kashim Shettima, as a distinguished senator, that made also some input into how some of the recommendations of the 2014 conference will be implemented. I'm optimistic that the National Assembly is committed to see through these processes, and we have been encouraged by the memoranda submitted by Nigerians, by interest shown by Nigerians in the 12 zonal hearings, and of course the national hearing held in Abuja for 2 days with a lot of memoranda and a lot of dignitaries and individuals from all walks of life, young people, women, physically challenged people participating in that process. And I believe that from July 1 to July 4, all things being equal, there will be a retreat of the Senate Committee on Constitutional Review to consider what has been aggregated from the public hearing, from memoranda submitted, and what has been made of it by the several consultants who are experts in political economy, political science, and constitutional law that have been engaged by National Assembly to assist legislators in the process. Well,
it's good to hear that there will be a retreat in July, but we hope that won't end up like the retreat that the Senate had on Electoral Amendment Bill, Electoral Act Amendment Bill in January, and now this is June. Not much progress has been made in that regard. But two quick questions before we wrap up. I would like to draw your attention to the fact that some people are of the view that a failure to do something about restructuring or to pay enough attention to it and the back and forth between government and the people is responsible for separatist agitations in the country. Would the senator think of the possibility of ending up in a new country called Oduduwa Nation, as has been proposed by certain persons, groups in the Southwest?
With respect, I will say that just as an aside, the work on the electoral amendment is at advanced stage, and I will want to assure Nigerians that hopefully before we proceed on our annual recess, the bill will be passed by the National Assembly. Assurance in that regard have been given by the President of the Senate. And on the question of agitations, you see, when you have an heterogeneous society with over 180, 200 million people, you cannot but have different ideas in relation to it. But the way I see it is that there has never been a time in Nigeria that there has not been such agitations. The previous PDP government had to deal with that agitation by calling a national conference in 2014. Even the Abacha military government in 1994 also had to call a conference. But the position that we are taking now is that there's no need for such conference. We should use the instrumentality of the amendment of Constitution to see to what extent we can go with restructuring and with devolution of power. And to say that whether agitation will fizzle away or not, I will say that as somebody who believes in human rights, right to self-determination is a fundamental right recognized by United Nations, but such right must be ventilated within the ambit of the law and must not lead to anarchy and breakdown of law and order. So for those who believe that is their own inclination, nobody will want to quarrel with them. They have not committed any offense. The only time they commit offense is when they take arms and ammunition or try to overhaul legitimate government elected democratically by the Nigerian people.
Well, finally, Senator Basiru, spokesperson of the Nigerian Senate, where are we with the Petroleum Industry Bill? That piece of legislation has been before the Nigerian National Assembly for almost 20 years. Now the Senate President has promised Nigerians that by July, we will see some concrete action on that bill, which is supposed to reform, recreate the oil and gas sector and provide new opportunities, both for investors and also for the communities and other stakeholders involved. Is there any guarantee that this time around, this ninth National Assembly will make significant progress with that critical sector and the bill?
Thank you, Doctor, for that question. And I think I'm in an informed position to make a statement in that regard. I'm a member of the Petroleum Downstream and Petroleum Upstream Committees of the Nigerian Senate. As at Thursday, close of work on Thursday, we have been able to conclude work on the gray areas in the legislation. And in order to clear those gray areas, we worked on Tuesday, Wednesday, and Thursday of this last week. And in fact, the Minister of State for Petroleum and the DG of the GMD of NNPC had to join with experts to make necessary clarifications to enable final decision to be taken on those gray areas. And I can assure you that the gray areas have been cleared, and hopefully within this week, the beginning of July, hopefully the bill will be laid, the committee report will be laid before the National Assembly, and we will do it in a way that expeditiously the bill will be passed before we proceed on July recess. It's been a very tasking work. It's been very challenging trying to aggregate the different interests of stakeholders, which include the community holding the production, the communities having interest in the frontier exploration, and also the general interest of the Nigerian community in deriving maximum benefit from it, the international oil company, and ensuring that they are competitive enough to be able to attract necessary investment into our oil and gas sector. But I assure you that the work is an advanced stage and necessitating that the bill will be laid anytime from now.
Well, Senator, I'm tempted to ask one more question, but if we can just do that in less than a minute. What are those gray areas that your committee identified? Because the petroleum industry bill is of great importance to many stakeholders. As briefly as you can attempt.
I will say that it is the interest of expeditious of passage of those legislation that I should exercise caution in talking about those gray areas. But I think all the necessary stakeholders are agreed on the resolutions reached on those gray areas. I think that will suffice for now.
Well, because the Minister of State for Petroleum has also been talking about gray areas. The Senate President has been talking about gray areas. And here you are also talking about gray areas. I think
okay, I will say that, Dr. Abati, the gray areas are now white now. They are no longer gray.
Anyway, I hope...
they are now white as a diamond are satin white.
Okay, I hope the resolution will be... acceptable to the various stakeholders and interest groups involved in the matter. I'd like to thank you very much, Senator Basiru, spokesperson of the Nigerian Senate, for joining us on This Day Live, the Sunday Talk Show. Thank you very much indeed.